think I'm ready. So thank you all for joining me today. My name is Alicia Mitchell-Mercer, and I'm pleased to present my dissertation titled Public Policy and the Civil Access to Justice Crisis, Exploring Lawyers' Perspectives on Regulatory Reform and Allied Legal Professionals. So this study examines lawyers' perspectives on allied legal professional programs as a means to improve civil access to justice in the United States. And so in this presentation, I will walk you through the study as it is presented in the 5 chapters of the dissertation. So beginning with chapter 1, the background of the research problem is that Legal Services Corporation 2022 and Rody 2016 report that about 44% of Americans, or some 147 million people, struggle to access justice for their civil legal needs. And this problem is due to many factors, but they include things like difficulty identifying that the problem that they have is a legal problem, or it's when they discover they have a legal problem, but figuring out how to connect that problem to potential legal remedies. Or it could be understanding the confusing legal forms or the jargon or the statutes or the procedural rules that are part of the process. It could also be overcoming physical or financial or technological barriers. And also, since about 1 in 5 Americans struggle with literacy, this can also be an issue. And then, of course, there are vulnerable populations like Native Americans and seniors and immigrants and veterans and the disabled who have their own unique challenges accessing the civil justice system. And these barriers make navigating the civil legal system without a lawyer very difficult. And for some people, it feels impossible. Additionally, there are UPL statutes that restrict the dispensing of legal advice to lawyers only. And Friedman and Engstrom 2022 report that nationally, non-corporate lawyers charge around $250 to $300 per hour for common civil legal issues. And this is unaffordable for most low and middle income Americans. So in the low income population, Legal Services Corporation 2022 reports that the low-income population group consists of about 50 million people, and in that group, there are 15 million children. And this income group faces significant legal challenges because they're experiencing, 74% of them are experiencing at least one civil legal problem each year. And despite the significant efforts of the nation's 10,000 legal aid attorneys, their limited resources and their limited practice areas mean that legal aid must turn away about half of the people who qualify for their legal services. So combined with this and other factors, that means that about 92% of the low income group is either going to be underrepresented or not represented at all in their civil legal problem. Now, as you move on to the middle income population, Rody 2016 reports that about 40 to 75% of the middle income group, or about 97 million people, also struggle to access the civil legal system. And this is the population that earns too much to qualify for legal aid services, but they don't have enough disposable income to be able to afford the services of a lawyer many times. So since lawyers can sometimes be unaffordable and legal aid offers limited help in the services that they offer, a common suggestion is to increase pro bono efforts. And one issue with this is that pro bono services typically offer only brief advice and counsel. So they don't offer full representation during a case that might take months or even years to resolve. And then additionally, according to Hadfield 2016 and Demiola 2019, even if you mobilized all 1.3 million of the lawyers in the United States to address these civil legal needs, they would need to provide about 180 hours or about 4.5 weeks of pro bono work every year for the pro bono efforts to really make a difference in the access to justice crisis. And currently, there are about 52% of lawyers who already work in those areas of high civil legal need that are contributing about 55 pro bono hours annually. So although their efforts are needed, obviously, and very commendable, this is well below what's needed to address the nation's civil legal needs fully. And there really isn't a practical way for pro bono efforts to scale enough to address the civil access to justice crisis. So when you take this and the other issues, we see what we are calling a access to justice gap. And this is the difference between the legal needs of low and middle income Americans and the available resources to meet those needs. So to help with the civil access to justice crisis, some states have introduced a new tier of legal professional, which IALS, which is the Institute for the Advancement of the American Legal System, calls allied legal professionals, or ALPs. And ALPs are licensed or they're otherwise authorized by their states to offer legal advice and assistance in specific areas of law to individuals who maybe wouldn't otherwise be able to afford a fully licensed lawyer. And depending on the state, allied legal professionals might work in family law, they could work in landlord-tenant law, they might work in consumer debt or limited jurisdiction civil or criminal matters, or they may work in administrative law handling things like public benefit issues. And these programs are structured differently depending on the state. So there are 2 states on this map that require ALPs to be supervised by a licensed attorney, so they're working under that attorney's license. And then in some states, they require, or rather they permit in-court representation, and then in other states, they don't. But regardless of how these programs are structured, the purpose of the program is to provide more affordable options for legal services. So what you're seeing on this slide is a map of the current status of allied legal professional programs in the United States, which Michael Holberg at the University of Denver helped me put together. And as you can see from looking at the green states, there are 7 that have adopted ALP programs. There are 3 states that are in purple that have considered the programs. They've even gone so far as to go through the public comment process, but they've ultimately chosen not to move forward with their programs. And then there are 7 states in yellow that have written proposals that are currently under consideration, even as I'm presenting to you now. And then there are 9 states in blue that have had some policymaker in that state show interest in an ALP program. So this could be a state Supreme Court justice or legislator. So in terms of the research problem, there have been extensive studies on civil access to justice, which is why my literature review is almost 200 pages, but there hasn't been a lot of research which focuses on lawyers' views on regulatory reform and ALP programs specifically. And so there's a gap in the literature regarding why lawyers might oppose or support these programs. The ALP map that I just showed you on the last slide shows that some states chose to move forward with their programs and some states did not. And then there are some states that are still considering it. And according to the literature, in every case, lawyers are very influential concerning these outcomes. So this gap is important given lawyers' sort of privileged position in shaping public policy and administration. Now, the significance of the problem is that more than 44% of the US population cannot access civil legal services when they need it. And these civil legal needs impact the most basic human needs. So we're talking about things like housing and healthcare and personal safety and economic stability and family structure and other things. And ALPs have been sort of introduced as a market-based solution for those who can afford to pay something for legal services, but perhaps not the rates that some lawyers are charging. So the literature shows that lawyers' opinions on these ALPs vary widely, with many opposing these programs. So it was something that I wanted to research. So the purpose of the research is to understand the supportive and the opposing discourse from lawyers on these ALP programs, and then to hopefully take those findings and inform policy discussions in states where they're having these conversations about whether they should implement these programs. And then the research questions are twofold. The first one is, in the context of regulatory reform, what themes of supportive discourse develop from lawyers' public comments concerning allied legal professional programs? And then the second one is, what themes of critical discourse develop from lawyers' public comments concerning allied legal professional programs? So in chapter 2, the literature review starts with an overview of the history and the concept of justice. And there is a lot here, but there are some things that are tied to the study's outcomes and the findings and my recommendations. So I wanted to give an overview on just the points that connect to those things. So when I started, I needed a place from which I could begin to view justice. It's such an abstract concept. It looks very different from person to person. Justice outcomes look very different from person to person. So the first place that I went to was scripture. I explored scripture to understand God's perspective on justice. And the literature shows that the Hebrew and the Greek terms for justice, equity, and righteousness are mishpat, tzedakah, and dikaiosune. And they appear over 400 times in scripture, and they're often used interchangeably. Now, according to Fisher and Friedman 2017 and Strong 2009, tzedakah typically represents righteousness or justice in the sense of doing what is right or what is just in terms of your personal relationships. And then mishpat most often refers to legal proceedings or justice and governance and the administration of laws and judgments. So, for example, Micah 6:8 says, "He has told you, O man, what is good, and what does the Lord require of you, but to do mishpat, which is justice, and to love kindness, and to walk humbly with your God." And then Deuteronomy 16:28 mandates, "Justice and only justice you shall pursue, that you may live and possess the land which the Lord your God is giving you." And here justice is tzedakah. So many of these scriptures show how important justice is to God, particularly in terms of governance and in terms of taking care of widows and orphans and immigrants and the poor. So next, I looked at the philosophical views on justice, and I identified 4 primary types of justice. And so I looked at Plato and Aristotle and what they had to say about distributive justice, which is determining who gets what. And I looked at John Rawls and Thibault and Walker and what they had to say about procedural justice, which is determining how to treat people fairly. And then I looked at Hammurabi's Code and the Levitical laws and Immanuel Kant and what they had to say about retributive justice, which is based on punishment for some type of wrongdoing. And I looked at Howard Zehr, who was talking about restorative justice, which is where he is trying to restore relationships to rightness after some sort of harm. And then next, I looked at literature concerning how the government has framed the concept of justice. So as 2 examples, the preamble to the US Constitution explicitly lists the establishment of justice as a primary goal. So it's listed as a goal before things like ensuring the domestic tranquility, providing for the common defense, promoting the general welfare, and securing the blessings of liberty for current and future generations. And this ordering suggests to me that justice is really a prerequisite for the other goals that you have. And then additionally, Madison stated in Federalist number 51 that justice is the end of government. It is the end of civil society. It ever has been and ever will be pursued until it be obtained or until it be lost in pursuit. And here Madison stresses the importance of justice in the functioning and objectives of government and society. And so then I go on to highlight the difference between the civil and the criminal justice systems concerning the right to representation, where indigent criminal defendants have the right to representation under the 6th Amendment in Gideon versus Wainwright, and the parties in civil legal matters do not have that same type of right. So next in the literature review, I explore the severity of the civil access to justice crisis, which I've already covered with you, so I'm not going to repeat that here. And then I identified the literature that detailed about 15 different factors contributing to the civil access to justice crisis. And of those factors, the ones that were most applicable to my study was the cost of legal services, the impact of unauthorized practice of law statutes on who can provide those services, lawyers' perspectives concerning regulatory reform, and then also lawyers sort of lacking the capacity to scale. So in the United States, there's been a relatively dramatic increase in the number of lawyers over the past 50 years. In the 1970s, there were about 326,000 lawyers, and by 2023, there were 1.3 million. And despite this surge or this increase in the population of lawyers, the gap for low and moderate income Americans to access justice has continued to widen. And then, of course, there are the limitations with legal aid and pro bono that I already discussed with you. So states aren't ignoring this crisis altogether. In pursuit of closing the civil justice gap, some states and other advocates have attempted to create some type of regulatory reform. So these reforms often involve leveraging the skills of non-lawyers. Now, there have been, for example, federal legal challenges in New York and in North Carolina and in South Carolina, and these are First Amendment challenges against the unauthorized practice of law. And then there have been court navigator programs, which are volunteers that help the public navigate the courthouse and the courthouse experience, with the most notable program probably being in New York. And then there's the community justice worker MARTA, where they're training non-lawyers in local communities to help people spot their problems and navigate those legal issues. And those are really prevalent in Alaska and Utah and Arizona. And then you have regulatory sandboxes and alternative business structures in Arizona, where they're taking the unauthorized practice of law in Rule 5.4, which prohibits lawyers from owning businesses with non-lawyers, and they're relaxing those prohibitions and allowing lawyers to work with non-lawyers like technologists, real estate agents, insurance agents, venture capitalists, things like that, in the hopes that they will be able to create new innovations that could potentially increase the civil access to justice gap. Now, the literature also suggests that leveraging non-lawyers to provide law-related services is not entirely novel. There are what I would call carve-outs in the law already that allow space for non-lawyers in many areas. So in the literature, I was looking at things like magistrates. In 32 states, magistrates do not have to have a Juris Doctor in order to be able to hear and adjudicate their cases. In my state of North Carolina, they have to have an associate degree at minimum. And then there are law enforcement officers who are, I would say, executing and applying those legal statutes directly in the field. And then at the federal level, there are 15 federal agencies. There's a report actually that came out in December of 2023 where they were talking about the 15 federal agencies where they're allowing non-lawyers to handle everything from simple to complex administrative law matters. And they've been doing something like this for almost 60 years. And then, of course, there are insurance agents and real estate agents, and they are engaging in some form of contract law. I would say they're negotiating on behalf of clients. They're, in some cases, even binding those clients to risk. And then there are tax preparers and certified public accountants who are interacting with legal documents at the state and federal level, so things like tax forms. And then there are jailhouse lawyers who are incarcerated individuals who are helping other incarcerated individuals under the landmark case of Johnson and Avery. And then, of course, there are the ALPs, which we are discussing today. So finally, there are some final, I guess, takeaways from the literature. The American Bar Association 2022B highlights concerns about notarios publicos who in Spanish-speaking countries function similarly to lawyers, but their services are illegal in the United States. And they sometimes exploit immigrants' unfamiliarity with the US laws. So in the literature, lawyers say that this is kind of a forewarning against allowing non-lawyers to practice law. But at the same time, there are scholars like Rody 2000 or 2016B who argue that non-lawyer legal help does not automatically mean that that's going to result in public harm. And then there are scholars that argue that a combination of public education and enforcement and creating legitimate legal service options that are affordable would probably help reduce those incidences of fraud. So aside from those concerns, Knowlton and DiMiola 2021 and Hill 2022 state that non-lawyers who assist with legal matters do not really cause any more harm than what's already happening in the attorney population, and that the incidences of harm in these non-lawyer populations are often lower. And then Rody 2016B also adds that most of the complaints that are regarding unauthorized practice of law to regulatory bodies are being brought by lawyers rather than the public. And Sandiver 2019, who is a sociologist specializing in access to justice, states that justice focuses on fair outcomes rather than the necessity for it to be a lawyer that's helping to promulgate those outcomes. So she suggests that many justice issues can be resolved without lawyers, and she encourages non-lawyer collaboration and public engagement to help come up with equitable remedies. So moving on to my theoretical frameworks, I chose Buchanan's public choice theory, and this is a theory that applies the principles of economics to political decision-making. And public choice theory suggests that self-interest drives decisions in the public sector, just as you would see in the private or the commercial sector. So in my study, this theory implies that lawyers, whether they're working in the public or the private sector, they might support or resist regulatory reform depending on how these reforms affect their personal interests. So lawyers might support allied legal professional programs, for example, if they think that hiring them to work in their firms might help them expand their firm's market reach, or if they are maybe legal educators who are incentivized to establish ALP education programs. But lawyers might oppose them if they perceive that allied legal professionals might dilute their professional standing, or if they view the allied legal professionals as competition for business. Now, one thing that I want to add about public choice theory is that Widercrest 2003 challenges traditional public choice models. And he's basically saying that motivations and political decision making extend beyond self-interest, and they might include things like altruism. So he points out that another issue is that they sort of diversity in the way that people look at justice and just outcomes, which we talked about earlier, also complicates the political decision-making process, even setting aside the issue of self-interest. And so those views, in addition to the public choice theory itself, are considered in my application of public choice theory. And then moving on to Kingdom's multiple streams framework, this is a model for understanding how policy is created in the public sector. It clarifies how public problems or public issues are translated onto a policy agenda. So in the multiple streams framework, it divides the policy process into 3 streams, which you can see on this slide in orange. And the problem stream basically identifies and defines a problem that requires government attention or intervention. The policy stream is where you develop viable options or solutions for whatever the public policy problem is. And then the politics stream deals with the current political environment. So that is things like the public mood or changes to public administration, or maybe even the interests of an advocacy group. And these streams tend to flow independently, but occasionally the streams converge at a moment in time to create a policy window, which you can see in gray. And this is an opportunity that allows for issues and proposed solutions to move on to the policy agenda. So in this study, lawyers interact with these 3 streams and the policy window when it opens as policy entrepreneurs if they are supporting these ALP programs, and as policy actors if they're opposing the ALP programs within this multiple streams framework. So chapter 3 sets up the methodology for the study, and I just have one slide for this. My method was a qualitative descriptive content analysis. My population was the approximately 1.3 million licensed lawyers in the United States. My sample was all of the lawyers who engaged in the public comment process across the 10 states that I studied. And these, by the way, were all the states that had undergone public comment periods at the time that I began my study. And a sampling method that I used was maximum variation or purposeful sampling, and I did this until I reached data saturation. And then in terms of the limitations on the study, this is really related to the public comments themselves. So it was about the quality of the archival data. I didn't have the benefit, like I would in a focus group or an interview, of following up to gain clarity on questions. So if I ran into a public comment where the attorney gave an opinion about his support or opposition, but he didn't articulate why, that was excluded from the study. So I only included public comments where there was a rationale for the position they were taking. So chapter 4, which is the data collection piece, is really where I just went to the websites. It was very easy, actually. They were already put together, the data sets. So I just went to the appropriate websites for the appropriate states. I downloaded the data set. And then there was a little bit of finagling to split the public comments into individual documents and upload them separately into Atlas TI. And then the coding process, this was a 5-step process that I went through, but it was really sort of an iterative and incremental process for me. It wasn't uncommon to take 2 steps forward and 3 steps back during this process. So I started with familiarization, and this is where I read the public comments to make sure that I understood the data set before I started coding. And as I was reading the public comments, I would create analytical memos, and I use this as part of reflexivity and bracketing to just kind of help me get in the right mind space before I started the open coding. And then I went into the open coding and I used inductive coding. So I didn't have a code book. I was really just trying to let the data speak for itself. And I selected the public codes using maximum variation or purposeful sampling. So this meant that I was trying to pull the codes or the public comments that were the most substantive and comprehensive and the most varied. And then I tagged the meaningful data segments with the descriptive open codes. And then for each open code that I created, which there were 94 of them, I created a memo to go along with those codes. And that, again, helped me with reflexivity, but also organization, so that I knew what the parameters were for attaching a particular code to a particular data segment. And then I processed 12 comments from each of the 10 states, followed by 3 more rounds of 3 comments each. I actually achieved data saturation after the 9th state when I had 157 open comments. At this point, Texas had not released their public comments from December 2023 yet. So when Texas's public comments became available in mid-December, I also included those in the analysis. And after I coded 21 comments from Texas to match what I had done in the other states, I ended up with 178 public comments, and I didn't have any new open codes. So I felt pretty confident at that point that I had reached theoretical saturation. And then the public comments themselves had a mean document length of about 3.1 pages. Through the open coding process, I used essentialist epistemology and experiential orientation to make sure that I was staying close to the perspectives of the authors of the public comments. And then in terms of lessons that I learned throughout this process, I reached out to Dr. Ahumada quite a bit. She helped me specifically in the open coding process. I was struggling with being too granular with my code. So she helped me find a balance between granular and broad. And then I moved on to step 3, which was the axial coding. And this is where I categorized the open codes into 8 axial key codes. And then step 4 was theme generation. And this is where I sort of distilled the axial codes into 3 supporting and opposing themes. And then I went on into theme interpretation, which is where I analyzed and defined the significance of the themes from the data. So the coding process was not really based on a single methodologist. It was developed partially from Byrne 2021, who was citing Braun and Clark. And then I also used Cresswell and Poth 2017 and Maxwell 2013, which were texts that we had in our qualitative research course. And then the data saturation piece was inspired by Tano 2017 and Bonsu 2018. So next, I analyzed the prevalence of the axial codes with the data set using Atlas TI's code document analysis tool. And so I was looking for frequency counts in the data. And so I downloaded the data, I uploaded it into Excel, and I used Excel's COUNTIF function to tally the unique document connections per code. And then after I consulted with Dr. Ahumada, I established a 25% occurrence threshold across the public comments for including axial codes in the theme development. And this 25% benchmark was set to make sure that I was excluding outliers and ensuring that the axial codes were significantly represented in the data. So on this slide, you can see the 8 axial codes, and you can see that one of them didn't make my 25% cutoff. So here I include an illustration to show the progression from the axial coding to thematic development under supportive discourse, which you can see on the left, and opposing discourse on the right. So in response to the research questions. And to save time, I'm going to share what the themes are, and then I'm going to go into their meanings when I get to chapter 5. So under supportive discourse themes, in the light blue or the lighter blue, you can see enhanced access to justice, ALP program viability and structure, and consumer benefits. And then under critical discourse themes, you can see the concerns about professional integrity and standards, questioning efficacy and consumer risks, and advocating for alternatives. And then in chapter 4, in the full dissertation where I briefly explain these themes, I also include 10 or more direct quotes to support the theme categories. So after this, I use Atlas TI for its code co-occurrence analysis to find themes that might have been overlapping in the public comments. And this kind of just helped me see how often the themes were appearing together. And so I marked the most frequent co-occurrences in blue on the slide for easy visibility. And so if you look at the bottom row, you can see that the themes that were with regard to questioning efficacy and consumer risk, they were the most prone to appear with the other themes. And then in the full dissertation, I also include Sankey diagrams to show the flow of one theme into the other. So before discussing the findings, I want to explain the PA pillars that I chose for this study. I chose accountability, inequity, and fairness. And to me, accountability was really about focusing on holding policymakers and lawyers and the judiciary accountable to the public for ensuring a justice system that is accessible. In my mind, there can be no justice if you don't have meaningful access to the systems that are supposed to be administering the justice. So the gatekeepers of the legal profession, in my mind, have a duty to make sure that the legal system is accessible to the people that that system is supposed to be serving. And then in terms of equity and fairness, this was really about equal opportunity to legal representation. About half of the population has access, at least financially speaking, and then the other half does not. So ALPs are thought to potentially promote equity and fairness in terms of representation, where they would be able to level the playing field here. And I suppose I could have used a representation pillar, but I chose equity and fairness. Now, as a last point, the preamble and scope of the ABA model rules of professional conduct, which most states have adopted, or I guess all states have adopted in some form, they also align very closely with these public administration pillars. These rules emphasize lawyers' duty to ensure that the legal system is accessible and that it's trustworthy, as well as the other duties that lawyers have regarding their professional behavior and ethical conduct. So the major findings in the study are really explaining what the themes mean under each research question. And so under research question number 1 concerning supportive discourse, finding number 1 was where lawyers were sort of indicating the need for these new approaches to close the civil justice gap, and they agreed that allied legal professionals could be one potential solution. And then under finding 2, lawyers were sort of explaining the practical and strategic importance of making sure that these programs are effectively structured. So there was a lot of emphasis on structure and regulations and enforcement and the way that they're implemented, and they wanted it to be done in a way that balances the need for their professional standards with expanding access to legal services. And then in finding 3, this was where lawyers were opining that properly regulated ALP programs could provide significant benefits to consumers without jeopardizing their safety or their legal rights. Now, under research question 2, which concerned critical discourse themes, this was really about lawyers expressing concerns about the impact of the ALPs on the quality and standards of the legal profession. It also tended to include the concept of protectionism, which sort of highlights lawyers' concerns about preserving their professional territory and their economic interests in the face of non-lawyers sort of practicing law and like encroaching on their territory. And then finding 5 was where lawyers were revealing concerns about the effectiveness of the ALP programs and the potential risk to consumers, particularly given that ALPs have less stringent education and training requirements than lawyers do, and also the potential impact on the client outcomes and the integrity of the legal system as a result. And then finding 6 was where lawyers were focusing on improving existing legal services and exploring other solutions to improve civil access to justice. So they were looking at things like increasing funding for legal aid, incentivizing pro bono work, using technological innovations, while at the same time they're expressing concerns about these ALPs. And so under this particular finding, the sentiment here was, like, please do anything other than implement these ALP programs, anything that is more lawyer-focused or lawyer-centric. So moving on to unexpected findings, in the data set, Florida's public comments included only comments from lawyers. And this was a deviation from other states. In my mind, I felt like this was also a missed opportunity to capture some diverse perspectives, mostly the perspectives of the public. This didn't really have a bearing on my study, really. Since I was studying lawyers' discourse, it actually made it easier. I didn't have to separate the two, but it was an interesting finding to me that that is the way that Florida chose to approach their public comment period. And then in terms of the local and state economic impact, there was no discourse concerning the impact on the state and local economy. There was lots of discussion in the data about the cost of programs and who was going to pay for the programs and whether lawyers were going to be forced to use their bar dues against their will and how much it was going to cost the public. In the literature, there were some reports, 2 reports from New York and North Carolina that were actually discussing the benefits to the economies when people receive these legal services. And so one of the examples that I think it gave was with regard to potentially an eviction case. Most eviction tenants do not show up to court because they don't think that there's a remedy. They think they're going to get evicted from their home anyway, so they don't waste their time. But if they could go into court with an allied legal professional or an advocate of some kind and be protected from the eviction, assuming that it was a wrongful eviction, then this would prevent them from drawing on community resources. So they wouldn't be pulling from resources like homeless shelters or accessing public benefits for housing. So there would be a cost savings to the economies when they have civil legal needs met in these different areas. So in formulating my recommendations, I considered very supportive and critical perspectives provided by lawyers in the public comments, and I passed these through 4 filters to develop my recommendations. I started with whether the need to expand access to justice beyond the low-income population to include the middle class is supported by data in the literature. And I felt like, yes, it was. There is no option for the middle class. Legal aid is not accessible to them. They sometimes can't afford the cost of a lawyer. Pro bono isn't scalable enough. So those were the concerns there. And then whether there's a persuasive data to support a shift away from solely relying on lawyers for legal advice. I was really persuaded by the 15 agencies in the federal government and by the magistrates in the 32 states and the tax preparers and those other carve-out professions. And then whether there are sufficient reasons to believe that ALPs can improve the civil access to justice gap, and if so, the safeguards needed to protect the public from harm without making ALPs ineffective due to overregulating. And I felt like the literature and some of the supportive comments were convincing in this regard. There did seem to be anecdotal and empirical evidence that they are making a difference in the communities in which they're working, and not just the ALPs actually, but also the other carve-out professions as well. And then the final consideration was whether there are examples of business practices across different industries that can inform the recommendations. And so I would say yes. I think that the medical and the mental health professions, which I included in the literature review as examples, are good examples of sort of stratification of professional work to make costs more affordable. I'm not arguing here that the medical field is the poster child for frugality at all, but I think that dollar for dollar nurse practitioners tend to be less expensive than medical doctors, and marriage counselors, for example, would be less expensive than a psychologist or a psychiatrist. And so the following are my recommendations. In the full dissertation, I connect them in a matrix to the relevant findings so you can tell what findings inspired what recommendations. But I'm going to go through these quickly because I know I'm already over time. So the first recommendation is to strategically implement allied legal professional programs, and strategic is the focus here. So under recommendation 2, I want to see the development of comprehensive training and education programs. And I thought that incorporating things like trauma-informed legal services and training them in alternative dispute resolution methods would be a benefit to the public. And then I wanted to make sure that these programs were facilitating diversity in the ALP candidates so that these ALPs were more reflective of the communities that they were designed to serve. And then developing a mentorship and advisory service for ALPs. This was really me rejecting the idea of supervision, but maybe reaching out to lawyers for mentorship so that these ALPs aren't working under their license, which most lawyers probably would not want to see anyway. But developing a mentorship relationship and then creating an advisory service. So if ALPs do have a question as they're trying to learn and grow in that profession, they can reach out to someone with their ethical dilemmas and ask questions about what to do. And then create a marketing plan for potential ALPs requiring malpractice insurance. There was a lot of discussion in the literature. Some states were like, well, lawyers don't have to do this, so ALPs shouldn't have to. But I felt like this is really low-hanging fruit in terms of protecting the public. Incorporating sufficient practice areas for program viability. I thought that if you're going to have this kind of ALP program, you need to have more than one practice area to make sure that there's sufficient uptake. This is an issue that they saw in Washington State. And then employing marketing and public education. This is just about making sure that the public is aware of who ALPs are and what their limitations are and what they can do. And then facilitating stakeholder development and engagement, determining a timeline for self-sustainment of ALP programs, which was about like how are the programs going to be funded and determining whether we're using licensing fees to fund the programs and how long would it take for them to be self-sustaining if that is the goal. And then establishing data collection methods for continuous improvement. And this is really about getting the ALPs to collect demographic information from their clients and outcome information, aggregated, of course, to help people understand how these programs are helping the public and to help make improvements from there. And then creating an independent agency or a board for regulatory oversight, which is really to kind of help prop up and sort of protect this new profession until they can sort of get off the ground. And then adopt an allied legal professional client privilege. I felt like this was important for candor, to make sure that the client is feeling like they can share whatever needs to be shared, and also to give them a bit of comfort that the information that they're sharing is not going to be divulged to anyone else. I rejected the estate and income cap to access ALP services. Some states were wanting to tell the public that, yes, you can use these ALPs, but you have to have income that's lower than 300 to 400% below the federal poverty guidelines. And I really felt like this was a disservice to the public, in that perhaps it was giving a nod to lawyers to stave off concerns of competition. But again, I feel like this goes back to accountability and equity and fairness. And then I was looking at creating a transparent discipline system. So in most regulatory bodies, if a lawyer has engaged in bad behavior, you can go online and find what that looks like. And I thought there should be something similar for ALPs. And then finally, considering lawyers' non-ALP recommendations to broaden access to justice. So in both the opposing and the supportive discourse, lawyers had great ideas for expanding access to justice. I don't believe that ALPs are a panacea for solving the access to justice crisis. So I think as many hands on deck as possible is important. And so as far as future research recommendations, I wanted to investigate the direct economic impact on the local and state economies, as well as the cost savings generated by ALP provided legal assistance. And this was really inspired by the fact that this information was found in the literature, but not in the data itself. And then examine ALP's effects on access to justice for vulnerable and marginalized populations, identifying challenges and benefits, maybe through a qualitative study. And then studying the impact of ALPs and legal education. So looking at the legal education to see if over time there have needed to be adjustments to the curriculum or to the skills that they're developing, and any specialized training that they need to improve those programs. And then finally, exploring the factors that influence the consumers to choose ALP services over traditional legal services in the first place. So maybe focusing on things like cost or quality or accessibility or public trust in that study. So that concludes my presentation. I'm so sorry I went that far over. Before I finish, though, I just want to say one more thing. I really couldn't have chosen a better university for my doctorate. Throughout this entire process, I think I have bugged Dr. Ahmada to tell her how well this program is supporting and complementing the work that I'm doing in my professional and advocacy efforts. And my CBU professors have been so encouraging, but also challenging. And this was just not simply an academic exercise for me. This troubleshooting justice issues is something that's been a big part of my life for a long time. So I just appreciate your guidance through the process, and I look forward to responding to your questions and hearing your feedback. Thank you.